You can lose your job on a Tuesday, and by that Friday, without doing anything wrong, you can already be 3 days into a countdown you didn't know had started. That is what happens the moment an H-1B job ends. Not after a warning, not after a letter in the mail. The clock just starts quietly. And most people don't even know it's running until they're already deep into it. Here's who this is for. If you are on H-1B right now, working, anxious about layoffs, maybe already laid off this week, this video is built for you, not for someone studying immigration law. For you today, with bills due and a status that depends entirely on a company that may not care anymore, by the end of this, you'll know exactly what the 60 days actually means, what kills people during this window, and the one move almost nobody makes in time. Stay through the part about day 61. That one number changes everything. Let's start with what most people get wrong on day 1. You get laid off. HR says something like, "We'll keep you on payroll through the end of the month, don't worry." Relief washes over you. You think, okay, I have time. You don't. Severance does not extend your H-1B status. Neither does a final paycheck. Neither does a verbal promise from HR that they're still processing everything. None of that matters to USCIS. The only thing that matters is one date. The date your employer reports as your termination date. That's when the clock starts, not your last paycheck, not your last day in the office, the termination date. So here's the first thing you need to do today. If this is you, find that exact date. Ask HR directly in writing what date they're reporting to USCIS. Get it in an email. Don't guess. Because once that date is set, you have up to 60 consecutive days or until your I-94 expires, whichever comes first, to do one of 3 things. Find a new employer, change your status, or leave the country cleanly. 60 days sounds like a lot. It is not. Let me tell you about a guy I'll call Arjun. Arjun worked at a mid-sized fintech company in Austin. Solid engineer, 6 years on H-1B, nothing dramatic about his case. Tuesday morning, his manager pulled him into a call, restructuring. Last day, 2 weeks out, but he'd stay on payroll through the end of the month as a courtesy. Arjun relaxed. He figured the payroll extension bought him time. He spent the first 3 weeks updating his resume, taking a short trip to visit a friend in Chicago, easing into the job search instead of sprinting. By the time he sat down and actually counted the days, he was already on day 38, not day 10, day 38, because the clock had started on his termination date, not his last paycheck date, which landed 3 weeks later. He had 22 days left, not 60. That's the trap. The number in your head says 60. The number on the calendar might already say something much smaller. Now, here's where it gets specific, because vague advice doesn't help anyone in this situation. There are really 3 paths. Path 1, transfer to a new H-1B employer. If a new employer agrees to sponsor you, they file Form I-129 on your behalf. And here's the part most people don't know. You don't have to wait for approval to start working again. Under the portability rule, the moment USCIS receives that petition, just receives it, not approves it, you're authorized to start work with the new employer. USCIS alum immigration, that receipt notice is everything. It's the thing standing between you and unlawful presence. But the filing has to happen before day 60. Not on day 60, before it. File on day 61, and portability simply does not apply. Doesn't matter if USCIS approves it 3 weeks later. You are out of status the moment the clock ran out, and that approval doesn't reach back in time to fix it. Path 2, change your status. If you don't have a new H-1B sponsor lined up in time, you can file to change into a different status, student visa, visitor visa, sometimes others depending on your situation. Immigration attorneys generally treat this as a last resort, not a first choice, especially the visitor route, because USCIS has gotten inconsistent about approving the switch back to work status afterward. Path 3, leave cleanly. If neither of the first 2 works out in time, leaving the US before the grace period ends keeps your record clean. Stay past 180 days of unlawful presence and you trigger a 3-year re-entry bar. Past 365 days, it becomes 10 years. Those numbers are not flexible. They are not negotiable. They follow you. Here's something almost nobody mentions, and it's the part one told you to stay for. A layoff does not automatically kill your green card case. If you already have an approved I-140, your employer-sponsored green card petition, and your priority date is current, you may still be able to move forward on adjustment of status even without the job that originally sponsored you. That's a big deal. People assume losing the job means starting over from zero. Sometimes it doesn't. The I-140 can outlive the job that filed it, but this only works if you knew it was possible in the first place. So check it. Today, if any of this applies to you, one more thing, and this one matters if you have a family, your spouse's status is tied directly to yours. If you're laid off, your spouse's H-4 status enters the same 60-day window even though they didn't lose anything themselves. Visum, if your spouse has a valid H-4 EAD, they can keep working through the grace period, but their long-term status still depends on what you do with your own 60 days. If you transfer, change status, or leave, your spouse's plan moves with yours. So here's everything. Put together, the day your employer reports your termination is day one, not your last paycheck. Get that date in writing immediately. You have up to 60 days or until your I-94 expires, whichever is shorter, to transfer, change status, or leave. If you transfer, the receipt notice is what protects you, and it has to land before day 60. Not on it. Check whether your I-140 survives the layoff. It might. Your spouse's clock runs with yours, even if their job is fine. And day 61 isn't a soft deadline, it's a cliff. If you're going through this right now, the worst thing you can do is wait for clarity before acting. There usually isn't time for that. Talk to an immigration attorney today, not next week. Count your real days, not the number in your head. And if you know someone on H-1B who just got laid off, send them this video before they assume Severance bought them time it didn't. I'm Nathan Reddy. New videos every week on exactly this kind of thing, the parts of the immigration system that move fast and don't wait for you to catch up. Subscribe, turn on the bell, and I'll see you in the next one.